So we want to welcome in Jess Bravin, Supreme Court correspondent for the Wall Street Journal. Jess, thanks so much for joining us, and we'd love to hear your question for the debaters.
Let me start with Randy. We've talked about the Equal Protection Clause of the 14th Amendment adopted in 1868. Well, in 1920, the Constitution was amended to extend the franchise to women. Does that subsequent amendment change the way that we understand what equal protection means? Does that have any impact at all on the way we look at those words?
Really interesting question to me, because I think the question is, did the meaning of the words change when the situation changed, or was the meaning of the words always the same?
Yes. I mean, the answer is it did change something, but it wasn't the meaning of equal protection. What that had the effect of doing, as I argue in my book on the 14th Amendment, is changing not the meaning of the Privileged Immunities Clause, but whether voting was considered to be a privilege of citizenship. That in 1868, there's generally conceded, and I think correctly, that the right to vote or the franchise was not considered a privilege of citizenship. And therefore was not protected by the Privileges or Immunities Clause. But by the time that the Constitution was amended, I think we argue in our book that the right to vote did become a privilege of citizenship. It was considered in the positive law to be a privilege of citizenship, of adult, that is, people who have reached the age of majority. So the answer to that is yes. The subsequent amendments did change the application of the 14th Amendment. It did not change the meaning of the 14th Amendment, but it changed the application of the 14th Amendment.
Okay, and for Thomas, I remember Justice Scalia saying when originalism was criticized that, you can't beat something with nothing, and this idea recurred to me when I watched the hearings for Justice Jackson, where Republican senators frequently asked her what her judicial philosophy or ideology was, and she said she didn't have one. Originalism, largely identified with conservatives. It has a general understanding of what it is we're talking about. But is there anything in opposition among progressives or liberals? Do they have any judicial philosophy?
There is progressive originalism, which I think sort of builds on some of the things I was saying, that in fact the original meaning of the clauses we care about is abstract enough that it can produce results that progressives are actually quite happy with. But I do think that, Justice Scalia, it was a genius move to sort of divide the world into originalism and non-originalism, because then he could say, like, non-originalism, that's completely incoherent. At least we've got a coherent theory on our side. And it's true that if one is not committed to originalism, that doesn't commit anyone to any particular theory. It just means you're not committed to that one. But I will say that I think a large number of non-originalist thinkers are committed to what you might call common law constitutionalism, that the constitutional law is like any other kind of law, and it calls for judges to decide cases the way judges decide cases, which is to say that you follow the precedents and the common law is inherently conservative in the sense that it's backward-looking. You're always looking to the precedents for the answers, but it's also forward-moving, because from the precedents you discern the underlying principles in the law, and then you see whether those principles do or do not apply to new situations as the world continues to change.
Jess, thank you very much for joining us. We've really appreciated your participation.